Hello everyone, welcome to iExamBee. I am Neha, your law faculty at iExamBee's LegalBee. आज हम इस वीडियो में कंटिन्यू करने वाले हैं अपना मॉक टेस्ट सीरीज डिस्कशन विद रिस्पेक्ट टू द कॉन्ट्रैक्ट एक्ट। उसमें आज हम डिफरेंट एस्पेक्ट्स को कवर करेंगे, बट बिफोर दैट डू रिमेंबर टू सब्सक्राइब टू आवर चैनल एंड प्रेस ऑन द बेल आइकन सो दैट यू कैन स्टे ट्यून्ड एंड स्टे अपडेटेड। अगर आपको कोई भी क्वेश्चंस हो, डाउट हो, कोई भी क्लैरिफिकेशन चाहिए विद रिस्पेक्ट टू एनी एग्जाम्स, यू कैन कॉन्टैक्ट अस थ्रू दिस ईमेल आईडी और यू कैन इवन कॉल अस ऑन दिस नंबर। इसके अलावा आप हमारी वेबसाइट को भी विजिट कर सकते हो, जहाँ पे कि आपको डिटेल्स मिल जाएंगे विद रिस्पेक्ट टू वेरियस कॉम्पिटिटिव एग्जाम्स। सो स्टे ट्यून्ड एंड स्टे अपडेटेड। टुडे एज आई ऑलरेडी मेंशन, आज हम डिस्कस करेंगे मॉक टेस्ट सीरीज कंटिन्यू करते हुए अपने इंडियन कॉन्ट्रैक्ट एक्ट से रिलेटेड, और उसके अंदर हम देखेंगे वेरियस एस्पेक्ट्स रिलेटेड टू कॉन्ट्रैक्ट्स, voidable contracts and void agreements. So moving on to our very first question of discussion for today. First question is, every agreement of which the object or consideration is unlawful is. So हमें पता है, हम अगर एक अग्रीमेंट में एंटर कर रहे हैं तो उसका जो ऑब्जेक्ट होता है या फिर यू कैन से द पर्पस, सो आइदर द पर्पस और द ऑब्जेक्ट वन इन द सेम थिंग हुआ वो, दैट और द कंसिडरेशन दैट हैज टू बी लॉफुल। बट व्हाट विल हैपन इफ जो अग्रीमेंट है उसका आइदर ऑब्जेक्ट या पर्पस जो है या कंसिडरेशन जो है अनलॉफुल है, सो व्हाट विल बी इट रिजल्टिंग इनटू, एंड यू हैव द वेरियस ऑप्शंस ओवर हियर, एंड द करेक्ट ऑप्शन फॉर दिस question is it will be considered to be a void one. Section 23 से related provision provide कर रहा है contract act में, and that says what considerations and objects are lawful and what not. Every agreement of which the object or consideration is unlawful is considered to be a void agreement. So that basically calls for that the object and consideration of the agreement that has to be always lawful for an agreement to be a valid one. Now moving on to our next question, that is question number 2. When is the object or consideration of an agreement unlawful? पहला हमने क्या देखा था कि अग्रीमेंट का पर्पस या ऑब्जेक्ट या फिर कंसिडरेशन either of these things if it is unlawful वो void कंसिडर होगा। अब यहाँ पूछ रहा है कि कब ऑब्जेक्ट या कंसिडरेशन जो है अग्रीमेंट का वो अनलॉफुल कंसिडर किया जाएगा, in what circumstances, and you can see the options are fraudulent, forbidden by law, does not involve or imply injury to the person or property of another, all A, B and C and either A or B, and the correct option is E, which is either A or B. So in case जो भी object या consideration अगर वो fraudulent है या forbidden by law है, then in that case the agreement will be considered to be an unlawful. So section 21 talks about effect of mistakes as to law. The consideration or object of an agreement is lawful until and unless that is forbidden by law, or if it is of such nature that if it is permitted will be defeating the provisions of any law, or is fraudulent, or is involving or implying injury to the person or property of another, or court is regarding it as an immoral or opposed to public policy. So in each of these circumstances जो consideration या object है agreement का, they are said to be unlawful, and so every agreement of which the object or consideration is unlawful is considered to be a void one. Now moving on to our question number 3, that is talking about every agreement in restraint of a marriage of any person is, whether it is void, illegal, voidable, other than a minor is void, including a minor is void, and the correct option is D, other than a minor is void. Section 26 कहता है agreement in restraint of marriage is void. Every agreement in restraint of marriage of any person other than a minor is void. So if it is a minor, then it is considered to be a valid one. Otherwise, if there is an agreement which is restraining any person he can go ahead and marry any person of his choice, then that kind of agreement that is a void one. And basically जो contract act में two sections have been specifically being provided which lays down that which kind of agreements if the parties enter into, that will be considered to be a void one, जिसमें कि in restraint of marriage is one of them. Now the next question is question number 4, which says two or more persons are said to consent. Consent is very important, हमें पता है, with respect to entering into any contract. So if two or more persons they are entering into a contract, so they are said to consent in what situation, or consent is said to be given when, and you have various options with respect to this, and the correct option is B, which is when they agree upon the same thing in the same sense. So consent means कि दोनों एक चीज पे एक सेंस में agree कर रहे हो, and it is defined in the section 13 as such that two or more persons are said to consent when they agree upon the same thing in the same sense. Now the next question, that is question number 5, it is mentioning that when consent to an agreement is caused by undue influence, the agreement is a contract which is illegal, which is void, which is voidable, voidable at the option of party whose consent was so caused, voidable at the option of the party whose consent was not so caused, and the correct option is D, which is voidable at the option of the party whose consent was so caused. So section 19A is providing that power to set aside contract induced by undue influence, and वहाँ पे mention करता है provision की when consent to an agreement is caused by undue influence, the agreement is a contract which is voidable at the option of the party whose consent was so caused, and any such contract may be set aside either absolutely or if the party who was so entitled to avoid it has received any benefit thereunder upon the terms and conditions as the court may consider fit. So when any consent to an agreement that is caused by undue influence, उस situation में जो agreement है that will be considered to be a contract which is voidable, the very option of the party whose consent was actually caused by such undue influence, provision इसका section 19A में है. Now moving on to our next question, that is question number 6. It mentions that a false statement made by a person who believes it to be true without any intention to deceive the other party is known as. So when any false statement is made by a person and the person who is making that false statement, he is himself believing that statement to be true without having any intention of deceiving the other party, then it is actually known as what? Fraud, mistake, misrepresentation, coercion, or none of the following. And the correct option is C, which is misrepresentation. Section 18 talks about misrepresentation. It says it is a false statement made by a person who believes it to be true without any intention to deceive the other party. So there is no intention of deceiving the other party, and the person who is making the statement, he himself is believing that particular statement to be true. So this is what misrepresentation means. Now moving on to question number 7, that says where a person who is in a position to dominate the will of another enters into a contract with him and the transaction appears on the face of it or on evidence adduced to be unconscionable, the burden of proving that such contract was not induced by undue influence shall lie upon whom? And you have the various options over here, and the correct option for this question is B, which is the burden of proving that such contract was not induced by undue influence shall lie upon the person in a position to dominate the will of the other. Section 16 is talking about undue influence. Subsection 3 mentions where a person who is in a position to dominate the will of another enters into a contract with him and the transaction it is appearing on the face of it or through the evidence etc. to be unconscionable, then the burden in such a situation of proving that such contract was not induced by undue influence, that will be lying upon the person who is in a position to dominate the very will of other. So जो dominant position में है के ऊपर basically burden है prove करने का contract जो है वो induced नहीं था by undue influence. Question number 8 that talks about which of the following is not an exception to the doctrine of privity of contract. So there are certain exceptions to the very doctrine of privity of contract, but the question is asking which of these is not an exception to the doctrine, and the correct option is D, that is time barred debt. So time barred debt, it is not an exception to the doctrine of privity of contract because it is an exception under section 25. Basically, doctrine of privity of contract means that only the parties to the contract, they have an interest in that, they are actually bound by the obligations in that, and only they can go ahead and get it enforced. But if we talk about that there are certain exceptions to the doctrine, then in that context we can say that even a stranger or person who is not a party to the contract can go ahead and sue the contract in certain circumstances which amounts to the exception to doctrine of privity of contract, and that is trust or charge, marriage settlement or partition or other family arrangements, acknowledgement or ostensibly. So in these circumstances, even if a person is not a party to the contract, he can go ahead and sue the other party if he has a recognition, interest and all. The question number 9 that talks about a contract is dash because it was caused by mistake as to any law in force in India. So it will be considered to be void, illegal, voidable, not voidable, not unenforceable. And the correct option is D, which is not voidable. So section 21 that is providing the provision with respect to this, and it mentions that effect of mistakes as to law. A contract is not voidable because it was caused by a mistake as to any law in force in India, but a mistake as to law not in force in India has the same effect as mistake of fact. So basically, if any person is having any mistake with respect to the laws which are enforced in India, then that contract will not be considered to be a voidable one because everyone is expected to know the law of the land. And last question for today's discussion is, what are voidable contracts? Voidable contracts क्या होते हैं? And you can see the various options over here, and the correct option is D. Contract enforceable by law at the option of the aggrieved party. Section 2I mentions an agreement which is enforceable by law at the option of one or more parties thereto, but not at the option of the other or others, is a voidable contract. So voidable is contract which can be avoided, and it can be avoided at the option of the person who is aggrieved in that particular contract. So with this, we come to an end of our discussion with respect to the mock test for the Indian Contract Act. And in my further video also, I'll be continuing ahead with the Indian Contract Act. So stay tuned, stay updated, and make your preparations 50% faster with us at iExam.